What you're about to see is a textbook example of how police powers fall apart when they're challenged by someone who actually understands the law. Nathan walks into a shop for a completely legitimate interview about CBD products, and within minutes, officers start bending logic, stretching suspicion, and inventing authority. This encounter isn't about drugs. It's about control, confusion, and what happens when bluff meets knowledge. Watch closely, because every mistake they make is caught on camera.
That gives you the right to...
If we find drugs in this premises, yes, and you were in this premises when we find drugs, then yes, that would give me the suspicion that you may well be in possession of drugs.
Even though I've told you why I'm here for a completely legitimate reason.
Tell us a lot of things. You may say you're here
as you can see, I've got my GoPro on the tripod, ready to interview someone about CBD products, as you can see here. My phone's there charging, so I can obviously film on that if this dies. I'm not doing anything illegal by being here.
Just gonna put that there.
You're not doing anything illegal by just being here, no. I appreciate that.
And I've told you my legitimate reason for being here, so you've got no reason to suspect me or have any suspicion I'm doing anything else other than what I've just told you.
You haven't given me your name.
I don't have to give you my name.
So how am I able to confirm if you are here for legitimate purposes?
Mike, at the moment he's indicated there's some drugs in this bag.
How would me giving my name then...
Fella, listen to me, okay?
I'm listening to you, yeah?
Okay, we are here to arrest this gentleman. He's been arrested for a drugs offence.
This is where the officer's logic completely collapses. He openly admits Nathan isn't doing anything illegal, yet still claims suspicion might exist if drugs are found on the premises. That's not how reasonable suspicion works. Not legally, not logically. Suspicion must be based on individual behavior, not guilt by proximity. Nathan explained exactly why he was there, showed his equipment, and even had a clear filming purpose. Once the officer accepted that, any lawful grounds to suspect Nathan should have ended right there. Instead, we see the officer try to reverse the burden of proof, demanding Nathan prove innocence. That's not the law. That's intimidation.
It's not enough suspicion.
Well, based on our intelligence that this gentleman here is supplying controlled drugs, not just being in possession of them, but he's a supplier of controlled drugs, and you are here with him, would then, to me, suggest there may be suspicion that you have been supplied drugs by him. Well, that is it.
If you search me, I don't consent to it, and I'll be taking legal action too.
So we're in the middle of an investigation at the moment, right?
Yeah.
Which we've got every right to do. Got a magistrate's warrant. We're on premise. All signed. Don't worry, you can have copies of that, as you well know. You can have all signed.
Where is it? Like, can we see it before you proceed?
All signed.
Can we see?
All signed.
Yeah.
The power to search is here. It's all sorted, and we're quite happy to share that.
Yeah, can we see it now? Like,
right. So
can we see that signature now? Like,
we've got that. Not yet.
Not yet.
But it's up at a different premises. So
surely, before you're doing all this, you should have to show that, because what if it's not signed?
No, the warrant. There might be some confusion. The warrant isn't for this premises. The warrant says home address.
Confidential to you, really.
So that's what the warrant is for. Obviously, this shop was open, which is why we've come in this morning, and the rest of the gentlemen. All right. So we don't need a warrant to be here now, because after being arrested, we have a power to search under Section 32.
This exchange perfectly highlights how messy the officer's understanding of their own powers really is. First, they lean heavily on the word warrant. But the moment Nathan calmly asks to see it, the truth slips out. It's not even for this premises. It's for the owner's home address. That makes it irrelevant here. Then comes a sudden pivot to Section 32 apace. Yes, Section 32 allows limited searches after an arrest, but only for the arrested person, and only within strict boundaries. It does not magically justify searching or detaining everyone else in the room.
Premises too. While you're searching.
You won't be able to go in there, because that's totally different.
Yeah.
At the moment, because you're like secure, right? We don't know whether you'd take anything into that warrant or whatever. So no, you won't be allowed access there.
Whoever is to you, friend, colleague, just a business acquaintance,
No,
whatever.
Just my friends.
Okay.
As far
He's been arrested for a drugs-related offence in terms of supplying drugs. Okay, so surely from that you can understand why I might suspect you may have been here. You may, I'm not saying you are, but you may have been here in order to be supplied drugs.
Yeah, I can understand that.
If I satisfy myself that that's not the case, then you won't be searched. All I said to you was, if you need to be searched, I've told you the powers in which we do them. But if you don't, then you won't be.
Like I'm saying, you don't have reasonable grounds. The only reasonable grounds you've got is suspicion.
So those reasonable grounds aren't yours to form, mate. They're mine. Okay.
Oh yeah, but then it's also you that'll be in the shit, so to speak. You know.
Well, maybe, but that doesn't concern you then, does it?
That line, Those reasonable grounds aren't yours, they're mine. Says everything about the mindset on display here. Reasonable suspicion is not a personal opinion or a badge power hunch. It's a legal threshold that must be objectively justified. Simply being near someone accused of an offense does not meet that standard. When officers treat suspicion as something they own rather than something they must justify, accountability disappears. This is exactly why filming matters. Because without scrutiny, this kind of thinking goes completely unchecked.
This helps you ground some more, just to give you some more information. There are some what look like medicinal cannabis, but there's also what in this bag and possession, what might not be. Just if that creates any more grounds for yourself.
Okay.
I'd be quite happy.
I'll have a skeg in the bag then.
So,
I'd be quite happy that.
So, on your opinion of something not being lawful, that would be enough
for the offence that's been investigated at the moment. Okay, and for what someone's been arrested for, and for what's been located on this premise at the moment.
So what's giving you the reasonable grounds to think that it's illegal and what you found? Because
I don't need to go into what I found. I'd just say what's on the premise at the moment.
So you found some medical cannabis that's legal.
Well, I'm happy to detain you, okay, for a lawful section.
All right, what's your name?
23, Misuse of Drugs Act. My name at the moment is Acting Sergeant John Dunn, and I'm based at the...
This is where the entire situation truly derails. The acting sergeant bases attention on something that might not be legal. That word, might, destroys any claim of lawful suspicion. Uncertainty is not evidence. Guesswork is not grounds. If officers aren't sure what something is, the law doesn't allow them to fill in the blanks with detention and search. Nathan wasn't seen handling drugs, wasn't acting suspiciously, and wasn't linked to any offense. This wasn't policing by law. It was policing by assumption.
I like to define my ethnicity. I define myself as white and British. Can I get your ethnicity, please?
Whatever you can see. What do I look like?
No, it's what we like to ask people. You can refuse if you like.
I don't answer any questions, to be fair, but what do I look like to you?
Okay, you do have the right to have a copy of the stop search certificate if you wish to do so. That's later, but I can explain that. I can also explain if you wish to complain and how you can go about doing that.
No,
obviously, everything that we're doing is it's been on record, it's on body worn, and I can see your recording there as well. I'm quite happy for you to hold that body worn camera. Nothing sharp, no?
Nothing. It's my headphones.
Thank you. Yeah, if you just turn around for my face.
That was search inside pocket, mate.
Oh, yeah, I can. Thanks for pointing that out. I don't want my face on social media, buddy.
You don't have that sort of right, I'm afraid.
Right, just point it that way.
I can point it wherever I want. I don't want my face all over your videos, but yeah, here I am.
But that's not going public, is it?
No, but I've got permission of the shop owner to be here filming, which trumps whatever you say.
Nathan absolutely schools the officer here. Calmly and lawfully, this is private property open to the public, and Nathan has the shop owner's explicit permission to film. That permission overrides any personal demand from an officer to stop recording. Police do not get to dictate filming on private premises when the owner consents. This isn't about courtesy or preference. It's about rights. The officer's discomfort doesn't create authority, and Nathan's calm response exposes that misunderstanding perfectly.
To leave, if that's all right. You can't stay, because we're going through a search now, so this is actually a crime scene at the moment, of which we're going to be looking through. I can't leave you in the crime scene, so I'll be asking you to leave.
I can't literally stand here now?
No.
Because that's what the owner wanted. He wanted me to stand here and just to make sure that, I won't interfere.
So if you're going to have to leave the premises now.
I can't even stand by the door and...
You can be outside, but you can't be in here.
It's not be a public place.
So I think in fairness, I take it as your friend, isn't he?
Yeah.
Telling you. So I think in fairness to him, he's the one in the cell, isn't he now? Right, he's under arrest. You were here when he was under arrest. Normally, I won't tell you that, because he'd have no right to know it.
Well, it's pretty obvious, isn't it?
Because you were present at the time, then you know it, don't you? But from here on in, it's an investigation now, right? And we can't be frustrated in doing that. And I just don't mean having someone filming. I mean the fact that if we find something, then it's a matter for him to account for it, because you're not under arrest, so you're free to leave. So I'd ask you to leave now, please, as we get...
Is that a request, though, or is that an order?
An order? That question cuts straight to the heart of lawful authority. Police cannot simply tell someone to leave because it's inconvenient. If it's an order, it must be backed by clear statutory power. If it's a request, it can be refused. Here, the officers rely on vague language like frustrating the investigation, which carries no legal weight. Nathan wasn't obstructing, wasn't detained, and wasn't under arrest. The pressure we see here replaces procedure. And that's exactly why the officers struggle to answer him clearly.
Please, because we're in the middle of investigation.
And I can say no to that, can I?
Not really.
Not really, or...
Yeah, because, no, you can't.
What happens if I do say no?
You'll be obstructing.
You're obstructing him.
So I do have to, it's
well, I'm
not just a request, is it?
That's how you want to... I'm asking you nice and politely.
If you're asking me, though, then it's like I've got a choice to say yes or no, innit?
Your mate's under arrest, right? I'm asking you to leave the premises, please. Okay?
And like I'm saying, do I lawfully have to do that? Or is that just a request?
I'm asking you to leave the premises.
Because the way that you're wording
it... to leave the premises at this point.
The way that you're wording it, though, it's like I've got a choice in it.
I'm asking you to leave the premises at this point, please.
All right, yeah.
Okay.
No worries, I'll grab my stuff.
Thank you.
What's your name?
You don't need to know my name, pal.
So, no, this phone, I know you've unlocked it.
Do you want me to show you your fingerprint as well? Just to double...
Whose fingerprint would put us in?
Who has access to that?
Me. No one else.
Of you?
No, this is my phone.
Is it?
Why would we both have access to a phone?
I don't know. I don't
Well,
know.
what sort of...
I'm not being funny, I don't know you.
You don't know, you just asked a question.
You're being very offensive, aren't you?
You just searched me for no reason, and then you're whinging about being filmed and stuff.
No,
you know what I mean? Saying that I'm being
The
argumentative.
officer will explain the reasonable grounds for the search.
Is that good enough for you?
Yeah.
Okay, good stuff.
What other stuff have you got yours? Just this?
Just that. There's me bag down here. Right.
Sorry.
We'll have to search this one.
You can search it all you want, Carl. Just get me stuff.
Yeah, that's yours.
I'm not going to...
No,
have I caused you any problems or anything so far?
No, you've asked questions.
I'm not going to cause you any problems. So. Oh, sorry, what's your name and number?
PC Limited, 1062.
All right, thank you, mate. You'll be famous.
This encounter is a masterclass in why knowledge matters. Nathan did nothing illegal, yet officers repeatedly tried to manufacture suspicion, stretch powers, and rely on authority instead of law. From the misuse of reasonable suspicion to warrant confusion, unlawful detention, and the attempted seizure of property. Every step exposed a lack of legal grounding. But calm, informed resistance changed the outcome. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more real-world police accountability breakdowns.